Commonwealth versus Phinney.
Thank you. Mr. Kunis?
Good morning, Your Honors. David Kunis, Assistant District Attorney for the Commonwealth. In this case, the motion judge abused her discretion in allowing the defendant's motion for a new trial on grounds of ineffective assistance of counsel because the defendant failed to establish that so-called third-party culprit evidence would have made a material and substantial difference in the outcome of the case.
Mr. Kunis, I have a couple of fact questions, if I may, please. When was Phinney first located for an interview?
Within hours of the crime. The crime was discovered about 1:30 in the morning. He was spoken to that weekend, essentially the next day.
Oh, so, because of what I'm wondering is if the fact that his camera had no blood was meaningful.
I would argue that it was not meaningful. The camera was found 9 years later upon his arrest when he confessed.
Yeah, his first interview.
That's what I meant when he was located and interviewed.
Correct.
So it was 9 years later. So the fact his camera had no blood is absolutely
correct. There was a search
irrelevant.
warrant for his camera 9 years later. The camera was located. It was tested. No blood was found on the camera. However, it was 9 years later. The defendant had ample time to wash or clean off any blood that was on the camera at that point. Interesting to note, the camera was damaged. There was testimony at trial that there was some damage to the flash attachment noticed after the crime, but that was not noticed before the crime.
Mr. Kunis, I understand your recitation and the law is correct, but it seems to me that as I read Judge Ball's, both of her judgments, orders, this, at very least, was not good counsel, correct? I mean, so are you essentially conceding, not that it was ineffective for the purposes of granting a new trial, but that this was not competent advice that this defendant, I mean, you can't, I think one can't with a straight face say that any reasonably competent attorney wouldn't at least have looked at the statements, correct?
Well, it appears that counsel testified that he did not recall seeing it, and if he had seen it, he would have used it, or he would have made some attempt to explore it and investigate it.
Am I not correct that there's a recitation somewhere, and it could have been, I forget which brief it was, but that there's no claim here that the Commonwealth didn't tell this attorney.
Absolutely not.
I mean, the Commonwealth repeatedly told this attorney, here are the statements, correct?
The documents in the court file show that the Commonwealth did give these reports.
And so it's fine for the attorney now to say, I don't remember, but it's pretty clear that in writing this attorney was told about these reports, right, and did nothing.
It's clear that he was given those reports by the Commonwealth, and it is fairly clear that he did not use, well, it's obvious he did not use them in the trial. Whether he saw them and decided to ignore them, or whether he or just didn't use them through, or whether he just didn't see them.
There's no suggestion that he did anything, correct?
That's correct. He did not use those reports.
Can we not at least agree that that was? There's no strategic reason for that, correct? I mean, he's not claiming this was strategy.
The judge found there was no strategic reason for that. However, what the defense counsel had to deal with here was the defendant's confession.
No, I understand that, but that's not our inquiry. All I'm trying to establish is it seems to me in your opening sentence you correctly went to, it's not a second prong, but
the second, correct.
I mean, this was just not good lawyering.
If that's the court's judgment of it, I was not there back in 1989 when the attorney
reasonable attorney wouldn't have at least
investigated this.
Yes.
It's getting into the mind of Attorney Glynn and how he would have used these if he had seen them or if he had seen them and decided not to use them. Again, if we get, and that goes to the first prong of Safarian, and even if we grant the first prong of Safarian, even if that's granted, we still have the second prong.
No, I understand that, but I just want to make, it seemed to me that we would be wasting an awful lot of time on the first prong of Safarian.
Absolutely.
Okay.
I would concede that.
Okay, we'll move to the second prong. I have a question that goes to the second prong. What, if any, corroborative evidence was there of the confession? I mean, you've got the confession, but what was there besides that?
Well, I would point the court to the Phinney opinion, itself in footnote 6, and all the other evidence of the defendant and his activities in that neighborhood around the time of the crime. Now, first of all, the defendant's confession, and it was a lengthy confession, and he
I know you have the confession, yeah.
And he gave details of the crime that only the killer would know. And this Court pointed that out in footnote 6 of its opinion. Only the killer would know certain details of this crime.
Oh, well, the police would know them as well, yes?
But the police did not tell those details to the
Well,
defendant.
that's what they say, and that's the whole issue, because the police typed the confession and had him sign it. And the whole issue at trial was whether this language could even have been used by this person. So the point of the story...
Go ahead.
Right, I'm sorry, finish.
I'm asking you, what besides the confession you had?
Okay. Well, as the confession, I would suggest is
Okay.
if we look at it, and I think
confession is good.
I've
What
put that
else?
forward in the brief. The defendant had a reputation in the neighborhood for being a peeping Tom. He was known among neighbors to secretly photograph sunbathing women who lived next door to him, where the victim lived. He photographed them through his window. He was caught looking out his window taking pictures. He was a photography enthusiast.
Does that make you a peeping Tom? I thought peeping Toms were when you go onto somebody else's property and peer into the window. If somebody is sunbathing in the nude, or sunbathing
in a bathing suit here,
and you're in your bedroom and you can take a photograph?
Well, there was some suggestion the defendant may have actually gone into the victim's house at one point to get some of their underwear.
What does some suggestion mean?
There was a point where, and this is again in footnote 6 I would point to, and it's in the trial record, where I believe it was the defendant's mother who returned some underwear to the girls next door. There was evidence that he had gone in there and taken underwear from the victim's home. There was evidence that he was, again, a photography enthusiast. He liked girls in hot pants, girls in bikinis, girls with good bodies. He liked to photograph them and ogle them.
Mr. Kunis, if we took that as an indication of guilt, we would be in serious trouble, I think. There's a whole industry that flourishes on that.
But
I don't want to minimize what happened here, but again...
But what we have is the defendant's conduct prior to the crime. The defendant's conduct in that neighborhood and his general reputation in that neighborhood for being this peeping Tom who would secretly photograph women. That reputation, if you look at the crime scene itself and how the victim was found, she was found with her underwear pulled down, her nightgown lifted up, and then she was bludgeoned about the head. There was a sexual element to the crime. It was essentially a sexual. It was a sex crime, in a sense. It was a murder, but there was a sexual element to it.
Was there
a
any
perverse sexual element.
Was there any forensic evidence tying her injuries to that camera? The camera, as I understand it, Yashika, having owned one at one time, can be a very heavy camera.
Yes, I mean, and the medical examiner did look at the camera and say it was consistent with the type of instrument that would be used to inflict the injuries.
There
were certain rounded.
One of the injuries.
Yes, and he did say that some of the injuries could have been accomplished with a rod-like instrument. However, there was one injury that had sort of a rounded edge to it, which was consistent with the camera being used with the camera. That's exactly what the defendant said. I used a camera when she woke up and I was pulling her underwear down. She woke up. He also said, I grabbed her arm and I started to hit her with the head. There was some bruising on her arm as well. He gave very fine details of the crime.
Mr. Kunis, was there some reason why a search warrant wasn't obtained closer to the time of this awful event?
The defendant was, I would say, a primary suspect early on. The police looked at a lot of other suspects, and that is in the record appendix that was presented to the motion judge. They looked at a lot of people for this crime. The defendant was pretty much suspect number one from the outset. It became a cold case because there was no physical evidence tying the defendant to the scene. It wasn't until years later when they had a cold case and the Lowell police, Detective Tousignan supervisor, suggested, take another look at this case. And that's exactly what they did, and that's where, when they went to speak with the defendant at his workplace, they invited him to come down to the police station, and that's where the confession happened 9 years
What's
later.
the defendant's physical stature? Is he medium build?
I'd say a medium build.
Is that in the record somewhere?
I believe. Well,
Well,
I'm
he
not
would
sure
be
if it's
the jury
exactly
could
in the record
the
describing
jury
him.
could see him. The jury could see him.
The jury could see him.
Without
Yes,
the-
I have seen him. He's I would say a medium build.
And there was some evidence that somebody had seen somebody fleeing the murder scene with blood on his shirt at the time?
As for the defendant's present at the scene, the defendant was seen out. He lived next door, rather. The defendant was seen at about 8:30 outside the home with something in his hand. The victim's roommate did see the defendant outside the victim's home.
But
there
he
was
lived
evidence
next door, you say? He
What's
lived
that?
next.
He lived next door.
So he was also outside his own house.
That's correct. There was evidence presented at trial of a man running through essentially downtown Lowell with blood on his shirt. He approached a motorist, said, "I need a ride to the hospital." The motorist said no and called the police and reported that. And that was introduced at trial.
Did anyone check local hospitals at that time?
There's no testimony about whether anyone checked any local hospitals. It was just simply presented as evidence of a possible third-party culprit by the
Why
defense
is
lawyer.
you said something in your brief that the evidence about Berger, I can't read my own notes, Berger, would have been inadmissible hearsay, but why couldn't the important information be introduced via the wife, such as his hours, the washing machine activity, the fact he normally walked home?
That would probably be admissible.
So it
But-
isn't inadmissible hearsay.
But it would be. But for the most part, a lot of the evidence that we have here is inadmissible hearsay. We have Lawrence Hickey's report, which is hearsay. It's his interview with Carol Barger. We have the neighbor.
No, but whatever you want to get out of Carol Barger, you can get, whatever the defense wants to get out of Carol Barger, the defense can get out of her if she comes back.
They would have to get out. They would have to
If she
get out
comes
of
back.
her. They would
Right.
have to get out of her.
If
and
she
no other
comes
source.
back, but if she doesn't come back, then they can use her testimony from the hearing.
That's possible. It was done under oath.
Right,
But-
so they would either get it from her in live form, or they would get it from her in recorded form.
But they would only get her observations of her former husband. They would not get a lot of his statements are hearsay, as are Lawrence Hickey's police report, the statements of Ruth Montblow, unless they wanted to call her. But Ruth Montblow's testimony.
Well, just because they're hearsay doesn't mean they don't come in as third-party culprit evidence.
Exactly, and that's where we get to the whole issue from the O'Brien case and from the most recent, the Rice case, about the admissibility of hearsay and the test the court applies for the admission of hearsay evidence for third-party culprit. And we don't have it here. It has to be relevant, for one thing. It has to be not confusing, and it must have show substantial connecting links of this so-called third-party culprit to the victim and to the crime. And
Mr.
here, there
Kunis-
are absolutely
Mr. Kunis,
none.
may I ask you this, and I may have missed it. Several times it's a lengthy, unrecorded interrogation. How long was the interrogation?
It was around 8 or 9 hours long. It began about 6 o'clock at night. I think it ended. But the defendant made several attempts to leave. He was allowed to leave. But then he essentially reinitiated the interrogation when he turned to the police and says, "What's going to happen next?" There was certain times, and this court has reviewed that entire that was the primary issue on his direct appeal.
Right. No, I know that.
And the court went through the entire interrogation and found that it was a valid confession the defendant had given, and that was the primary issue in his direct appeal. If we look,
Of course, as you know, there's a practical problem in really determining what occurred in the course of an 8 or a 9-hour interview. There's a practical problem. You've got, it wasn't videotaped, so there's a practical problem. Yes, the court may have concluded that the trial judge didn't abuse his discretion and make findings that were clearly erroneous, but that doesn't tell us what really happened in that room. And indeed, this whole case was about, because the confession really was the only evidence here, was about the nature of the confession. And surely, if that's your defense, it's not a very good defense in front of a jury. It really isn't a very good defense unless you can demonstrate that there is a substantial possibility that someone else also committed this crime.
well, the defense counsel in this case did attack the confession. He attacked it
Right, he had
repeatedly,
to.
and he attacked it at trial as well,
Of course.
with expert testimony.
But it's not a very successful defense before a jury in a horrible murder case unless there's also evidence, unless the defendant can also present evidence that someone else may have committed the crime, someone the police neglected to look at or looked at but stopped looking at for some reason. And that's what this is all about. That's what this is all about. You have someone who, a few days after the murder, a woman living, a block away from this murder?
It was several. It was not right next door. It was the Barges lived at 104 South Main Street, and the crime scene was 29. So it was a
Couple of blocks away.
It was a ways down the road.
That her husband was becoming increasing. The report at the time was actually quite specific, and I would suggest pretty powerful lead for the police to follow.
But again, you have to take that report apart and that information apart piece by piece and find out whether it meets the test that this court applies in circumstances where there is evidence of a third-party culprit.
But let's assume for a moment that Mr. Glynn read this report, and he said if he'd read it, he certainly would have conducted further investigation and attempted to use it. right?
He
I mean, it's very
testified.
hard to do this 20 years after the fact.
He testified to that, but he also testified that this report, this information came to him through Lawrence Hickey several weeks after the Supreme Court's opinion, the SJC's opinion in 1993.
Well, Officer Hickey came to his office and said, you know, did you get my report of 12 years ago, a couple of nights after the murder, where I interviewed this woman who had called the police, and all of this about her husband and the axe handle that he carried and going to work and the washing of clothes right after the event, and
Well, and a few things about that,
and statements
though.
he made about the fact that this woman may have deserved to die and she wasn't as good as...
That was not specific to this victim. The statements about she deserved it, first of all, it's hearsay. It was also
All right,
in
let's
keeping
get beyond
with-
hearsay for a moment.
It's also, but that's also in keeping with what we know about Mark Barger. She testified Carol Barger, his ex-wife, testified at the motion for new trial hearing that Mark Barger had somewhat archaic views of women. He think women should not wear short skirts. Women should basically be kept in the home barefoot and pregnant. That type of an attitude. We know that Mark Barger was probably not a very nice guy. I mean, I think that's pretty clear from the record. There was a domestic situation going on inside that home. There were shoving matches. There was a lot of angry fights and bitterness. It was a domestic situation, and Mark Barger was in he was seeing a psychiatrist. She was seeing a psychiatrist. There was antidepressants. That is not.
And the
at
psychiatrist, what, told her, you better get out of the house with your kid because this guy is really violent. And this was, what, 2 days before?
If that
And he
is-
said, if I don't kill myself, I'm going to kill somebody else? I mean, all of this
that
is
was
sort of
that was
interesting.
said several weeks before the crime. If I don't kill myself, I'm going to kill someone else. But we have a domestic situation. Is that anything like? What we know about Mark Barger is that he's involved in a very heated domestic problem. Now, domestic abuse and domestic situations happen in a lot of homes.
But you're
And that is
limiting
what
it.
this is.
You're limiting it because you say domestic abuse is limited. Maybe some people take out their violent feelings on somebody else.
But if we have to look at the facts of this case, we look at Mark Barger's situation, and then, Your Honor, we look at what happened to Marian Alexander. It was a perverse sexual element to that crime that is not in keeping with anything that we know about
Maybe
Mark
that's a
Barger.
decision for the jury to make, and what you're saying would need expert testimony.
But again, I would go back to substantial connecting links between Mark Barger and this victim, and there are none. There are no substantial connecting links. We have a domestic situation.
Where did the Bargers live in relation to the victim's home?
Excuse me?
Where did the Bargers live in relation to the victim's home?
They lived at 104 South Main Street, and the victim lived at 29. There was no
And
real...
he walks by there on his way to work, correct?
He
And it's-
he drives by there on his way to
Well,
work.
he was walking at the time.
At the
of
time,
this
there was
So
a
he
testimony that
walked
his
by.
car was broken. And he kept an axe handle in his car, and she never saw it leave his car.
Yeah, but you in your brief, you say he never had access to it. Why wouldn't he have access if it's in his car? He could reach in his car and pull it out.
And walk to work with the axe handle, and walk home with the axe handle, and he...
Throw it
Well,
away after
reason-
he used it.
The reason
Throw
he
it
had the
away.
axe handle, as I understand it, is because it was very dangerous to drive in that neighborhood. So if he had to walk to work that night, why wouldn't he have taken the weapon with him? If it was dangerous to drive in the neighborhood, surely it was dangerous to walk in the neighborhood.
Mark Barger came home about 4 o'clock in the morning, and...
Well, we don't know that. We know that at 4 in the morning
She woke up at...
Yeah, and
But
he was doing his laundry.
Right. But it was quite common for Mark Barger to go out drinking after work, and that much we know about him. So Mark Barger was at a bar that night with an axe handle in his hand.
All right, we
having
know
drinks
that.
with
He was
friends.
at a bar. We don't know anything.
We don't
do
know
we?
that, but that was in keeping with what we know about Mark Barger. That was something he frequently did, and it was consistent with him. He was a drinker. He liked to drink. And he would go out after work at 11 o'clock with friends. Again, are there any connecting links? There are no connecting links between Mark Barger and between Marian Alexander. She was, that night, she was home. She was presumably studying. Her friends were gone out. She was alone. She had no boyfriends. There's no reason there's no evidence at all whatsoever that Mark Barger knew Marian Alexander or knew who she was, or had any reason whatsoever or any motivation at all to kill her. And none of his statements were specifically
Mr.
about...
Kunis, your time is way over. Thank you. I know you've been answering questions from the justices.
But I would rest in my brief, and I would ask the Court that there was simply insufficient evidence here for a new trial, and that it was an abuse of discretion for the judge to do so. And I rest in my brief for any remaining issues.
Thank you, Mr. Kunis. Mr. Yannetti?
Thank you, Your Honor. May it please the Court, my name is David Yannetti, and I represent the appellee in this case, Roland Douglas Phinney, Jr. Your Honors, this Court should affirm the decision of a Superior Court justice and grant my client a new trial.
What are the connections between Mr. Barger, who you claim may be the third-party culprit, and the victim here that would warrant, for example, the court permitting the admission of hearsay evidence?
Well, I think there are two answers to that. The first is there was substantial evidence developed that he had the motive, means, opportunity to commit this murder, and also acted like a guilty person would and demonstrated consciousness of guilt in the aftermath of the murder. The second answer to that, Your Honor, is that with regard to Mark Barger's statements that he made, which are really the only hearsay evidence that or potential hearsay evidence that we're talking about here, I would assert that those aren't hearsay at all because they are not offered for the truth of the matter asserted. The connecting links, Your Honor, go to exactly what evidence we have that Mark Barger committed this murder.
But if what you say is true, then any time there is a nut within a couple of blocks of a crime scene, that person's conduct could be put to a jury as a potential source of a third-party culprit.
I disagree, Your Honor. Anytime there is evidence of a maniac down the street, 1 block away, it's in the record, just 1 block away, who has demonstrated through his statements that he knows the victim, that he
How does he know her? What was in the evidence that said that he knew about her?
Well, there was nothing in the evidence at trial, and the jury should have heard this evidence.
No. What was in the evidence at the motion for a new trial that he knew her?
Well, when confronted by his wife the next morning, or when she mentions the fact that there had been a murder of this poor girl down the street, he says she probably deserved it. Number one.
How does that indicate that he knew her?
That, in conjunction with the fact when she says, well, the paper is saying she was a really nice girl, he says she's not the goody two-shoes that they made her out to be. There was further evidence that the police received that a neighbor had also said that Mark Barger knew some girls from the college. The victim was a girl at the college. You take all of that into consideration, Your Honor, and that is powerful evidence that he knew her, disliked her, and wanted to see her dead. And take that into conjunction.
That's powerful evidence?
Well, I would argue that to a jury, Your Honor.
Well, of course you would argue that to a jury. But what's the power in that?
Well, I think the power in that is once you take that evidence in conjunction with the fact that he had the means to commit this murder, he had that axe handle that he disposed of, that the police never looked at, and is consistent with the rod-like instrument that Mr. Kunis just spoke about. You talk about the fact that he had the opportunity to commit this murder, which is that his whereabouts are unaccounted for at 11:15 to 11:30 p.m. The medical examiner testified that the victim was found at 1:30 and that she would be expected to live for 2 hours or a little bit more with those injuries, which would put the murder at 11:15 or 11:30, which would, I would argue, to a jury, if given the opportunity.
Well, that's all very interesting, but how is it a substantial connecting link?
Well,
it really doesn't place him there.
Well, Your Honor, specifically with regard to this issue of substantial connecting links, please, that only applies to the statements that Mark Barger made. It does not apply to the axe handle evidence. It does not apply to his opportunity to go into that house and the fact that the door was unlocked. It does not apply to his consciousness of guilt in the aftermath of the murder. It does not apply to the fact that he fled the area 3 weeks later. It does not apply to the fact that he got rid of the axe handle and his wife never saw it again. And it does not apply to the fact that he washed all of his clothes for the very first time. Only time.
No, wait a minute. You say the only time he ever washed clothes?
Yes, Your Honor, the only time he ever washed his clothes after coming home from work.
I thought there was some reference to the wife's testimony that he had washed clothes before, but this night she was awakened because the washing machine was unbalanced, and that's what woke her up.
Your Honor, you're correct, except the evidence was adduced at that trial. The evidence was that during the 5 years that they were married, her estimate, 23 years after the fact, was that he may have washed his clothes once or twice per year. I put the question to her, how many times of those once or twice per year did he ever wash his clothes after coming home from the night shift? The answer was none. Take all of those into consideration, Your Honor, and my argument is that provides a substantial connecting link and a lot of circumstantial evidence that Mark Barger was involved here, which would justify the admission of hearsay. However, again, my argument is that those statements aren't hearsay at all.
Okay, so what you're saying, Mr. Yannetti, is whether or not that's powerful evidence, people could differ, but you should have had the opportunity to present it to a jury so the jury could have decided whether it was powerful.
That's precisely the point, Your Honor. That's precisely the point. In July of this year, Your Honor wrote an opinion, Commonwealth versus Cohane, which stated a long-standing rule of this court, which is that a criminal defendant has a constitutional right, federal and state, to present evidence that someone else committed the crime.
Mr. Yannetti,
Yes.
let me ask you this question. This defendant's conviction was affirmed in 1993. This victim was killed in 1980.
Correct.
And we have a delay of from 1993 until 2002 before he brings this claim.
Correct.
I think it would be reasonable to assume that it would be very difficult to retry this case. I don't know which witnesses are available. What, if any, attention should the court pay to the long delay in bringing this motion for a new trial?
Very little, Your Honor, I would assert. I would argue to the court that with regard to the Commonwealth's ability to retry this case, they would be in a far better position to do it than in other cases where their evidence depended on, for instance, eyewitness testimony, identification evidence, things of that nature where they'll have to gather up their witnesses again and test their memory 20 years later. This case, as this court has already noted, depends almost exclusively on a confession, an alleged confession, typewritten by police. That confession is still available. The police officers, I've seen them. I know that they're still around. That is the sum and substance of the Commonwealth's case. When this case was reviewed back in 1993, this court, like the jury before it, was misled into believing that the confession is all there was and that there is no other suspect. That's why the jury found my client guilty. That's why this court affirmed, ultimately, the conviction back in 1993. I would assert, Judge, that it would be a far different trial this time around, and not because of the time delay. It would be a far different trial this time around because the jury, for the first time, would learn that there was powerful evidence that somebody else did this. That would cause them to be more open to the fact that this confession, alleged confession, was not voluntary.
Mr. Yannetti, could I ask you one other question?
Yes, Your Honor.
There was apparently an expert who testified about the verbal capabilities
Correct.
of this defendant.
Correct.
I take it that quite often what might happen is, to the extent possible, police try to use the words that somebody is saying, quotations and so on. But obviously, when the police are doing a report of an 8-hour interrogation, the police may have summarized or used other words.
Correct. And not to interrupt, but it was 10 or 11 hours, Judge.
Okay.
He's signing this confession at 4:45 in the morning.
Okay. What was could you tell me more about the nature of the expert testimony and what we know, if anything, of this defendant's mental capabilities or...
The testimony at trial, Your Honor, from this expert was that based on his evaluation of my client, he believed my client was borderline retarded. He said that my client was introverted with very poor social skills and a very limited vocabulary. That was the person that these two homicide investigators picked up unexpectedly at his place of work, brought back through a series of locked doors into an interrogation room, and basically kept him there for 11 hours. I know what the police testified to at trial in terms of him being free to go, but as Justice Cordy brings up, we don't know for sure. And certainly it was in the interest of the police to put this alleged interrogation in the best light possible.
Mr. Yannetti, could I ask something
Yes,
else?
ma'am.
At the time, there's obviously a delay between this homicide and when the defendant is arrested. Did the defendant know, the defendant obviously knew in the immediate aftermath that he was considered a suspect?
No doubt.
If he wasn't a suspect, he was interviewed and correct?
Yes.
I mean, so that whether the police considered him a suspect or they were simply getting information for him, that's not the gist of my question. My question is, immediately before he was picked up at work, did he know at all that the cold case had been reopened?
He knew that, I believe the testimony was that he knew that some of his friends had been spoken to again. To answer the question, the Court's question quite simply. Your Honors, this Court wrote in its original opinion in Commonwealth v. Phinney that there was evidence introduced that would permit the jury to reject the confession and to come back with an acquittal. That was way back in 1993 regarding the first trial. This was not an ideal confession. Again, it was not recorded back then, and I understand that this was taking place before this Court's line of cases, beginning with Diaz and continuing through DG and Batista. However, all of us were alive in 1989. All of us know that this is not back in the days of 8-track tapes. Tape recorders were readily accessible, relatively inexpensive. They chose not to tape record any of their interrogation. So again, we have to rely on what they said. And I understand this Court has reviewed the confession already. That's not the thrust of my argument here today. However, this confession, again, was not evaluated in light of the third-party culprit evidence, which was not introduced at trial, again, because his attorney failed to read the police reports. He got these police reports, did nothing with them. And it's important to note, I think, also, that this testimony and evidence about a third-party culprit would have been buttressed and supported by an effective Bowden defense. This Court has stated...
That's what the motion judge pointed to, correct?
Oh, correct. Oh, definitely. Yes, and that was certainly a ground for the motion for new trial.
It doesn't matter as far as your argument goes, but do we know from the record whether the attorney actually, I know that it's stated in your cover letters that you provided him with, that the Commonwealth provided him with the Officer Hickey's report, but do we know whether he simply didn't have the report because of oversight or whether he just didn't investigate it?
Good question. The attorney testified during the motion for new trial. His testimony was that I showed him individually the 3 notices of discovery that were filed with the Court, and he acknowledged that these reports were listed in there. Mm-hmm. He testified affirmatively that he never saw the reports. He said that he gave the notices of discovery to his secretary to cross-reference them against the actual documents in his possession, and he just trusted whatever she did. So apparently, his testimony was that 3 times he gave the notices of discovery to his secretary, and she must have missed those 3 reports 3 consecutive times.
But the notices of discovery don't mean that each time the report accompanies the notice of discovery. It just says this is what we have provided in the past.
I believe I believe, Your Honor, is correct. At least one of those notices of discovery was a letter outlining what we
accompanying, and then the next 2 would be this is what has been provided.
That's very likely, and frankly, I can't remember if they were provided twice or if they were provided
once. And we don't know if the secretary did it. We don't know if he told the secretary to do it. I mean, all that is.
But the bottom line here is.
So we don't know whether he had the report or whether. I mean, as I say, it doesn't make any difference to your argument, but it just make a difference when we write up the decision. Right. We don't know whether he had it or whether he had it or if he had it and didn't look at it.
Right, and the bottom line is it was his responsibility to get them if he didn't have it.
I say it doesn't make any difference to your argument.
Right.
I take it from your answers to Justice Cowan, Mr. Yannetti, that I assume at some point, and I'm not asking for any privileged information, that you asked to see trial counsel's file.
The way this worked, Your Honor, is that I was the second attorney in on this motion for new trial. If you read documents provided to you in the Commonwealth's record appendix, you will see that the first motion for new trial and accompanying memorandum was filed by attorney Patrick Cannell.
I'm simply asking whether we actually know whether at some point the documents were in Attorney Glenn's files or not?
The testimony from Officer Hickey during the hearing was that, with regard to Attorney Glenn, we don't know. Another attorney wound up looking at this case after Attorney Glenn was approached by Officer Hickey, and Officer Hickey testified that that second attorney had the file, and the reports were not in there.
Okay.
That was Rappaport. That was
Rappaport. Absolutely no evidence introduced at trial as to any investigation or work that Rappaport did.
Okay.
Is this strictly an abuse of discretion review standard,
Yes, Your Honor.
even though this judge was not the trial judge?
Well, it's true that because she was not the trial judge, this Court is in as good a position as she was to evaluate the trial testimony. However, clearly, she heard substantial testimony at the motion for new trial. She was able to judge the credibility of witnesses and see how they were answering questions, and she made specific findings with regard to who she found credible and who she didn't. So I would assert she is entitled to deference in that regard.
Thank you.
Thank you, Mr. United.
Thank you, Your Honor.